Thank you, Your Honor. May it please the court. Counsel. My name is Vidhya Reddy, and I'm here on behalf of Defendant Appellant David Howard Rooney. Mr. Rooney appeals his conviction for burglary of an occupied structure, and this court on appeal should hold that the evidence was legally insufficient to establish that the structure at issue qualified as an occupied structure on either the adapted for overnight accommodation of persons alternative or the occupied for storage or safekeeping of anything of value alternative that were submitted to the jury in this case. This court in Pace recognized that the word adapt means to make fit, often by modification. And the statute necessarily contemplates that structures or buildings are dynamic in their lifespan. A structure that is initially built for one purpose can subsequently be adapted to a different purpose. So a building that is initially not built for overnight accommodation of persons can subsequently be adapted for that purpose. But the inverse also has to be true. A structure that's initially built or used for the overnight accommodation of persons can subsequently adapt out of that purpose. And
I'll give you a hypothetical, Ms. Reddy. I'm not saying it's the facts of this case, but let's say you had a vacant house that nobody had been living in for 10 years, and then transients do start living in it. And there's evidence in the record that around the time of the defendant's entry into the premises, there were people living in it. Would that support a burglary conviction under the facts of this, otherwise facts of this case?
I think certainly that could support a burglary conviction under the alternative of being used for any purpose. I think if a non-habitable structure is put to that use by somebody with a legally cognizable interest in the property, I think it would fall under that other alternative that was not submitted here, that it's actually for some activity. I'm not sure it would fit under the adapted for overnight accommodation of persons alternative unless it's minimally habitable, unless it's fit in some way for the overnight accommodation of persons, because
in the test of that, whether people are actually using it for that purpose, right?
In whether that's true.
We just let the jury decide that. What's unfair about that?
In a great number of cases, it will be a jury question, but here it's not, because of the fact that everyone, even the state, really acknowledged that it was non-habitable. But more importantly, it wasn't put to that purpose by the city, which is the one with the legally cognizable interest in the property. As to trespassers in particular, the dissent in the Court of Appeals makes the point that the statute must necessarily contemplate that the person that is putting the structure to the particular purpose or use is someone that is legally entitled to do so. And so what use trespassers make of the property is not pertinent under the statute. And that's really supported as well by this court's language in Pace, where it recognized that burglary is really about protecting an occupier's interest in the right to occupy the property with a sense of repose. And trespassers, even if they actually put a structure to a particular use, certainly cannot be said to occupy it with any sense of repose in that property.
Well, let's say it's a house I'm renting and it's been foreclosed on, and the sheriff's given me, issued a decree telling me to leave, but I'm still living there. Are you saying that that house can't be a subject of a burglary?
I think the structure would still be adapted for overnight accommodation of persons. So I think maybe there's a fact question in that case, because it's at least adapted. Even if that particular person is not using it for that purpose, it's still adapted for that purpose. So I think if you have either of those things, either a structure that's still fit and continues to hold that purpose, even if it's not presently being used, I think then you have a fact question of whether it's adapted. Or if it's a structure that is not adapted but is actually being used, you have a fact question under that circumstance. But here we have neither. We have a structure that's not.
Was there any evidence in the record that the city condemned this building or withdrew an occupancy permit from this building? Because in most cities, you cannot even stay in a residential home without a valid occupancy permit from the city.
There was no evidence specifically on that question.
State presented evidence showing that this building was fit or adapted for occupation because the city allowed occupation there?
No, no, Your
Whose
Honor.
burden would that be
It
if
is.
that was a requirement?
It is the state's burden to show that it is habitable. If that's the theory of that it's adapted because it's habitable, it's the state's burden to show that it was habitable and that there was, an occupancy permit that would allow that. And in fact, the state, the city, by boarding up the property, objectively demonstrated that it did not intend that this property to be used for overnight accommodation of persons, whether by transients or anybody else.
Does boarding up the property show an intent to protect the interior for the alternative of protecting what's stored inside?
On that alternative, I think the city testified, there was testimony that the city boarded up the property in order to protect the structure itself. They wanted to protect the building, but that does not establish that anything was being stored within the property.
Can you count the copper pipes and other things of value that are fixtures or built into the building as something stored there or not?
No, Your Honor. Those are parts of the building, and like I said, the city wanted to protect the building and keep it intact, but that doesn't mean that it was occupying it for storage or safekeeping of anything of value.
What about, let's say, this seems like a case you can come up with a lot of hypotheticals. What about a chandelier? Would that be the same thing? What if your client was accused of removing a chandelier, valuable chandelier, and taking it out of the property?
I think what the individual is intending to take out of the property is really kind of irrelevant to the question of whether the property itself is an occupied structure.
Would that present a jury issue, because one could say that a chandelier, even though it's affixed, is something that might be moved around or might be stored there? Would that present a jury issue as opposed to what we had here? I think was a furnace and pipes.
Perhaps it's a closer question. I still think it's part of the building itself, and the statute necessarily contemplates that something's being stored there other than protecting the building itself.
It
Well,
has to be
Counsel,
more than a
it's
fixture.
not just storage, but it's storage or safekeeping, right? Anything of
Correct.
value. Following up on Justice Waterman's question, and Justice Mansfield's, if there's a chandelier, why isn't the city's act of boarding up the property a clear indication that they were trying to safekeep something of value in that building?
I think because of the way the statute is phrased, occupied for purposes of storage or safekeeping, and that necessarily implies that there's something being stored or kept for safekeeping other than the property itself. And that's substantiated by what we know is the fundamental purpose of the burglary statute, that it was never intended to vitiate interest in the property itself, or the ownership interest in the property, or to protect the property. It's to prevent the culmination of situations that are dangerous to personal safety, that that an intruder entering this property is going to, come into contact with the occupier of the structure.
Well, I think that may be true at common law, but now with the statutory change and the definitions of burglary, it clearly is not limited solely to personal private repose in a property. A burglary is meant to cover any number of protection of property. That's why you put locks on your storage units or anything else. And if you break into somebody's storage unit, I don't think you say that there's nobody there that's going to occupy it in that circumstance. But it's clearly a burglary if you're breaking and entering a place where you're storing things, or even if you have one thing in there versus all sorts of things. So wouldn't you agree that it's not limited so much to that narrow focus of the old common law of what the personal repose would be?
I disagree to an extent. I agree that it's been expanded greatly beyond common law. I certainly agree with that. I think, though, that the fundamental nature of burglary is trying to deal with concerns of personal safety still exist, even though it's been expanded to this idea of storage. Because I think the idea is that if something is being stored there, then you probably have someone that's coming and going from the property to put things in storage, to take things out of storage. And so there is this heightened likelihood that an intruder is going to come upon somebody.
Well, and that's why we have different degrees of burglary, isn't that correct? A burglary third, like in this case, is going to be without anybody present, no persons involved at all, and then all of a sudden the charges get more significant if there are people there. And so the law takes that all into consideration, don't they?
It does, but as a minimum, to have a burglary, you have to have some kind of purpose or use that the structure is being put to. And although there's been a great expansion of statutory burglary from common law burglary, this court has recognized in Pace and Sanford that the legislature elected to specifically retain that separate requirement of, some purpose or use to which the structure is being put.
Can I ask you a question on the chandelier? That would be a theft at the very least.
Correct.
Tell me about whether the law of fixtures has anything to do with our definition of burglary.
My position, the defense position, is that the statute necessarily contemplates that the storage or safekeeping alternative of the burglary statute is for something being kept, in the property, and that.
What was the evidence at trial about that? Was there any?
The only evidence was that there were things in the structure that certainly had value, as scrap value.
But did the owner testify that the building was boarded up as a means to protect the copper that was in the building?
No.
In fact, what the demolition status was, we're talking about permits and so forth. There was a formal approval of demolition of the building?
Correct.
By the city?
Correct.
So the owner has said to, tear it down, and it, in fact, was torn down several days later?
Yes, 4 days after the incident at issue. And there's no testimony that any of that, the things that the state relied upon as being things of value, that the metal with the scrap value or, the fireplace mantle with the historical value were, ever removed from the home. Or
Any qualifications on the, was it a permit? I don't remember. The demolition, I seem to recall in the brief something about authorization to demolish. Were there any qualifications, or could the contractor just at will go in and knock it over?
That's correct, Your Honor. I believe in the contract they were required to do so within 30 days.
But wasn't there also testimony in the record that there were certain people, because of the historical nature of the house, that had authorization to enter that and take out the mantle if they wanted to? Wasn't there evidence of that in the record as well? And that there was a list of people that if they wanted to go in there, they had the permission to go in and to take anything of historical nature or value, as opposed to a scrap radiator and the things that we're talking about here, copper wire, which certainly has value, and the radiators, I guess, that they took out, the heavy metal radiators. And these people didn't have any authorization to do that, did they?
The people that actually, the defendant, you mean? Correct. No. That's correct. There were people that the city was looking for to take the pieces, the historical pieces of the structure of the home if they wanted it. No one did. It wasn't removed from the structure, by the city or by anybody else before the date of demolition. And ultimately that, all the component parts, whether it's the metal parts that had scrap value or the parts that had historical value, purportedly had historical value, everything was demolished and taken away and removed from the structure. And so even assuming those things do, qualify as being things that could qualify for being kept for safekeeping within the structure, they certainly did not at the time of this offense, which was approximately a month after the notice to proceed on the demolition was to have taken place. With that, if there's no more questions, I will yield the rest of my time. Thank you.
Thank you as well, Ms. Reddy. Mr. Bowler.
May it please the court, counsel. Houses are built for people to live in. That's really what this case comes down to. The Iowa Code criminalizes the burglary of a structure that's adapted for overnight accommodations. And the quintessential structure that's adapted for overnight accommodation is a house. Houses are designed for people to live in, whether those houses are in good neighborhoods or bad ones, whether it's a good house or a bad house.
that's a good theory, but didn't the prosecutor abandon that theory on rebuttal argument?
No, Your Honor, I don't believe the prosecutor did. In closing argument, prosecutors are thinking on their feet, and this prosecutor made a tactical choice about his rhetoric. He describes himself as a cut-to-the-chase kind of guy, and what he said to the jury is he's not relying on that theory. But a prosecutor on his own, speaking during closing argument extemporaneously, can't modify Iowa law.
But here he says, I'm not saying it was adapted for accommodations. I couldn't say why don't you guys fine for me on that element because at one time it was adapted for overnight accommodations. That's not what the law is designed to do. I don't think that really is fair here. I mean, that seems to me, you're changing course. You're right. I mean, he's not the final say on what the law is, but that's not how the case was tried, right?
I've got a two-part answer to that, Your Honor. First, a prosecutor during closing argument can't change how the crime is charged without formally amending the trial information. Here we have the charge of burglary, and the jury was properly instructed on all of the alternatives supported by the evidence. The second part of my answer is the district court has a duty to instruct on all alternatives that are supported by sufficient evidence. That's a duty that comes from this court's rules of criminal procedure and civil procedure. The prosecutor on his own couldn't modify those instructions without the judge's permission. And the Court of Appeals and the district court both concluded that substantial evidence supported both alternatives given to the jury, adapted for overnight accommodation.
But you know, it may be a house, but things change over time. I mean, we have areas in Des Moines that have been gentrified where houses are now businesses. So is your position that if you broke into one of those, it's always a house because it was originally adapted for living? I mean, that makes no sense, no logic.
Your Honor, this is going to sound like a Dr. Seuss answer, but I promise I'm going somewhere. A house is a house until it's not a house anymore. And what I mean by that is a house is adapted for overnight accommodation until it doesn't fulfill the basic duties of a house, until it doesn't provide shelter from the elements, until it wouldn't permit people to live here. I certainly
no heat, no running water, a leaky roof, no real shelter from the outside. Is a house still a house? That's the question. And what evidence do you have that this structure that was abandoned by the city, abandoned by the owners, taken over by the city, subject to demolition 4 days later, was still going to be a house?
I agree that is the question we're talking about here. Was this house still a house? And the answer is yes. I certainly wouldn't choose to live there. It's not a good house. There's no question about that. But does it fulfill the very basic necessities of a house? Does it provide some shelter from the elements? Yes. Could someone store items or things, as the statute talks, of value in that house? Yes.
Well,
Let me give you another. Go ahead.
Well, let me put this spin on it. Burglary is a serious offense because a home is our castle. And so we want to prosecute this case in the same way that you would prosecute the seriousness of breaking into a house that is occupied, a house that is not in disrepair. Isn't that a little unfair to treat this situation where the purpose of the law is to protect the sanctity of a place where people live?
I don't think it is unfair, Your Honor. Your quote about one's home being their castle, that goes all the way back to Blackstone. That's common law definitions of burglary. But of course, we don't have common law crimes in the state of Iowa. In
we statutes, in light of their historical dimension, I mean, obviously, our statute is much broader than common law, and we all agree with that. Nonetheless, you look at its historical background and you compare it with other crimes, which is what Justice Cady's doing. There may be no doubt that a theft occurred here and other gradations of crime, but burglary has enhanced sentences compared to third-degree theft or whatever, as we all know, and there's a reason for it. And the reason for it is really twofold. I mean, adapted for habitation addresses itself to people living there and feeling secure in their abode. And then the storage addresses putting material things with a specific purpose for storage. But this thing was frankly quite, as I gather from the record, I don't think you'd dispute, I mean, quite dilapidated. It wasn't, it didn't have an occupancy permit, I'm quite sure, although maybe the record is silent on it. Boarded up, and some transients on occasion. I take it the record, and you'll correct me, I know if I'm wrong on the record, but there were some transients there that occasionally
Correct.
lived there. Boy, isn't that a long way from the Pace case and a long way from really being adapted for habitation? And plus, it was scheduled for demolition. So you understand my concerns?
There are a couple things going on in your question. Take me back if I go off course. Part of what we've been talking about and part of what we heard in the appellate defender's argument is this notion that the subjective interest in the property matters. If the city chose that they didn't have an interest in that property anymore, it shouldn't be governed by the burglary statute. And I want to push back hard on that because that doesn't make any sense.
Okay, I'll take objective. What objective indices are there that this was adapted for habitation when there was no running water, no permits, and scheduled for demolition?
I'll go back to what I said earlier. Certainly not a good house, not somewhere I would choose to live, but it still fulfilled the minimal qualities of what makes a house a house. It provided some shelter from the elements, and it did provide for the safekeeping or storage of things of value. The house was boarded up to keep people out and to keep the things that were in the house in there.
All right, let me give you another hypothetical. I mean, this case is kind of rich with possibilities for that. Have you been out to Living History Farms?
I have.
All right. What about if somebody broke into the 1850 farm, you know, the one out kind of off in that separate area that looks kind of like Laura Ingalls Wilder, and took some of the contents? Could they be charged with burglary?
Yes, Your Honor, and that goes in some ways back to what Justice Apple was asking about. Does a house need running water, electricity, all those things that certainly I want in my house? No, the statute doesn't contemplate that. The little house on the prairie could have been burglarized too, just like a townhouse out in the suburbs could. The basic indicia of a house is that it provides some shelter from the elements and that you can keep things there. You can safekeep them and you can store them. The house in this case met those alternatives. It was adapted for overnight accommodation, even if it wasn't a great house. It was adapted for the storage and safekeeping of things of value.
Let's talk about the second element. What does the law of fixtures have to do with whether things are stored? Either, you know, the law of fixtures says things are part of the realty, and the things that were taken were truly fixtures under property law and part of the realty. How can you have it a fixture for one purpose and not for another purpose?
I think the law of fixtures has nothing to do with our burglary statute. It's a statutory crime. The legislature's its own lexicographer. If the law of fixtures had been intended to apply to our burglary statute, it appears somewhere in that code section. But instead, we have very broad language. Anything of value. Things is about the broadest word that the legislature could have possibly chosen. Carpentry is a thing. A fire mantle is a thing. Copper wiring is a thing.
A nail, if you took a nail out of a board, you'd be guilty of burglary under your theory.
That's correct, Your Honor. Any part of the structure. But I would suggest...
Indeed, any structure. All structures are used for storage. Nails and the screws and whatever.
As long as they meet the first portion, the descriptive portion of the statute, building structure, appurtenance, and so on, then I believe that's
quite
correct.
broad, of course. Yeah, so every structure of any kind, in whether it be one of those portable little things that you put your lawnmower in, even though there's nothing in it, you know, one of those plastic things that you buy for $429 or whatever, there's not a thing in it, but that would be a structure used for storage under your view.
Yes, Your Honor, and I believe the legislature intended that. This language is very, very broad.
If someone came in here at night and took one of those pictures off the wall, that'd be a burglary.
Yes, Your Honor.
When would you ever have a theft then?
Just because one crime is met doesn't mean that the legislature intended for totally different circumstances.
But your definition subsumes all thefts into burglary, it seems to me.
Thefts from a structure? Yes, Your Honor. I believe that's the purpose of the burglary statute. That's what the legislature intended with the broad language they used. But let me suggest to the court that this case is easier than that because we have the cast iron radiators in this case. And I think that's more equivalent to what we think of as a thing that's in a house. If we, instead of talking about this bad run-down house, we're talking about a nice house, an expensive house. If someone breaks in and steals the expensive furnace from the basement, that's certainly a burglary. The furnace is stored and safe kept in the house, just like the cast iron radiators were here.
That's a house. What if they stole what if they broke into a garage and they stole that's not adapted for something? I don't think you could agree anything's not adapted for habitation, but let's say you can find one somewhere in the world that doesn't meet your broad definition, and they took the heater out of there. Is that a burglary?
It could be, Your Honor. I think in those circumstances, that's where we're looking at the PACE two-part test. Like the Court of Appeals, I have trouble applying the PACE language to something that's clearly adapted for overnight accommodation like a house. A driveway is a harder question. A garage is a harder question. There we are looking at the purpose and the use to which the structure is put. If someone had been living in the garage, in your example, if it had been adapted, cleaned up, if the garage appeared as if someone was living there, it probably would qualify as a burglary.
I'm not talking about something that you can agree with, and I don't think there's anything under your definition that's not adapted for overnight occupancy or occupancy. Someone took the furnace, which is clearly a fixture. Is that a burglary under the storage element?
Yes, Your Honor. If we are going to look at our policy history, whether one's home is their castle, then the policy reasons support that being a burglary in your example as well. Because people go to their outbuildings. People go to the structures on their farm, for example. If they hear someone breaking into there to perhaps steal a fixture, like the furnace, that creates the exact risk that the burglary statute aims to prevent. When someone's breaking into a structure, then other
But do you store a furnace? Or do you use a furnace as a fixture as part of the house?
I'm not sure I follow your question, Your Honor.
I'm having the same problem with your argument here. The furnace is part of a building that's not adapted to use. If you go into one of those buildings that's not adapted to overnight or accommodations, whatever the definition is, and take the furnace, is that a burglary under the storage section?
Yes, Your Honor, it is, because the structure is adapted to store or safekeep an item like the furnace in the house. Thing is the broadest possible language the legislature could have chosen to use. If I were sitting across the street, I'm not sure I could come up with a word more broad than thing. Any thing of value, certainly a furnace is a thing.
What significance is it that the house was boarded up? And I take it both the doors and windows were boarded up?
The record's not entirely clear. You can see in the photos that portions were boarded up, and we know that some portions of the boarded up structure, it had been ripped down by the vagrants or perhaps by the defendants in this case. We certainly know there was an attempt to keep people out, and I think that also reflects an attempt to safekeep the items that were inside the house. So to answer your question, I think it favors the state's interpretation of the evidence that the owners or the persons with interest in the home had attempted to safeguard or safekeep the items within the home. Some local organizations, a historical group and Habitat for Humanity, had made various trips inside the house, and the city gave them permission to take these things of value that we're talking about, the historical carpentry, the historic fire mantle. As I understand it, none of those groups happened to take anything, but that's just additional proof that these are things of value that were stored or safe kept in the house. I'd ask this court to affirm the defendant's conviction for burglary because houses are built for people to live in.
Thank you, Mr. Bowler. And a rebuttal?
Thank you, Your Honor. To the state's point and the Court of Appeal majority's conclusion that houses are somehow different than other structures, that they are inherently and in perpetuity adapted for overnight accommodation of purpose or of persons, regardless of what purpose they're put to, regardless of their condition at any time in the future, I would disagree. The statute does not carve out any sort of exception for houses. It does not say that structures that are initially adapted for the overnight accommodation of persons are automatically occupied structures and that we don't apply the second prong purpose or use test to them. So yes, this structure was a building. It had four walls.
Isn't that a fact question? I think just by the mere fact that everybody's come up with a dozen hypotheticals here, leads me to the conclusion that you make the argument, it's clear that the state makes the case that it's a house, and a house is a house is a house. You're taking the argument that, a house is a house is a house until this point in time, then it no longer becomes an occupied structure adaptable for habitation. Isn't that your argument? Okay, so isn't that really a jury question, just like you have the 8 hypotheticals that we've talked about today? Isn't that clearly a question for the jury to decide? And I assume it was argued, wasn't it?
It was, Your Honor. And my point is that it's a legal question whether something is adapted. So in many cases, it might present a factual question, but the statute requires that it be adapted. And the statute necessarily contemplates that...
You didn't dispute the fact that this is adapted for habitation. It is a house. It was adapted for habitation. You're just saying that at a certain point, the character of it changed.
I'm saying that at the point of the burglary, it has to be adapted for habitation at that point. At the point of the burglary, this was 4 walls and a roof, nothing else, no plumbing, no electricity. Every building would qualify with those parameters. It was just a building. The statute doesn't say that all buildings are occupied structures, and by including this requirement that the structure be adapted for overnight accommodations, the legislature must have intended that to mean something more than every building, because they could have just designated every building. And
well, give me an example where, and I think Justice Wiggins was kind of talking about this a little bit, where a storage unit that I have in my backyard, that clearly would fall under the burglary statute, wouldn't it?
if it's occupied for the storage or safekeeping of anything of value. If,
Well, but just by its nature, it's a storage unit, so
but by its nature, it's not necessarily occupied. And I think that's the key distinction, and that's what this court has indicated in Pace and Sanford, that there has to be a purpose or use at that time. It has to be occupied. So,
well, the purpose and use of it is for the storage of this property.
right, but that doesn't mean it's occupied.
Whether I have any property in there or not.
Right, that's correct. That is the purpose of the structure, but that doesn't mean that, it's occupied for that purpose. The burglary statute necessarily says that there has to be some, use or activity that's put to the structure. So the fact that it's just a structure and it exists is not enough.
It's occupied, and this is the thing about the statute. It says adapted for overnight accommodations of persons, comma, then occupied for persons for purposes of carrying out a business activity, or for the storage or safekeeping. So would the structure in the back actually be subject to a burglary? Because the storage isn't occupied by a person for storage.
That's exactly.
Because occupied has to modify both of those.
That's correct. That's correct, Your Honor. That's my
Does the fact it was boarded up really help you? I mean, it's not really adapted for use if the door's blocked by plywood. You can't go in and out to store things or to live there, right?
I agree, Your Honor. And by boarding it up, the city affirmatively took steps to adapt or modify the structure out of both its, initial purpose for overnight accommodations and, indicated that it's not a place that's being used for storage or safekeeping of anything of value. They wanted to protect the structure itself, but there's nothing inside that they wanted.
And a reason cities or other people board up their property is to keep it from bad things from happening inside. It can turn into a crack house or something.
Sure.
And the fact that it's scheduled for demolition, that's not determinative though either, is it? Because I can give you examples of people that had a decent house they tore down in order to build something else on that lot.
I think it goes to the continued purpose or use to which the structure's put. Perhaps in a typical case, maybe that would present a fact question, but here it doesn't, for the reason that it was neither habitable, and that was not the future purpose, to which the city intended the structure, to be put at that point. With that, I would urge this court to conclude the evidence was insufficient to establish that this structure qualified as an occupied structure. Thank you.
Thank you as well. That concludes the arguments, and the case is now submitted. The bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.